Hi, this is Mark Schroeder from GSHC Surrogacy Agency, and today I'm speaking with Aadil Mangalji, who is a partner with Long Mangalji in Toronto, Canada, who's going to explain a little bit more about the immigration process in that country. Aadil, how are you today?
I'm doing great. How are you, Mark?
Excellent, fantastic. First question, can you explain what the difference is between a Canadian citizen and a Canadian permanent resident?
The difference is basically in the rights that you have in Canada. A citizen is considered an individual who's able to stay in Canada permanently. They are given a passport. They have all the rights of citizenship. They can vote. A permanent resident is not yet a citizen. So basically, we like to think of it as citizen light. They have the right to live in Canada. The big thing, though, is that they have to maintain their residency in order to maintain their status, which basically means that at the end of every 5 years, they will have to renew their residency. And at that point, they'll have to show that they were living in Canada for at least 2 out of those 5 years, or they were with a spouse, a Canadian citizen spouse overseas for at least 2 out of those 5 years. So you can essentially lose your PR status, but you cannot really lose your citizenship status.
And if the intended parent is a Canadian citizen and has a genetic link to the baby, what is the surrogate baby's Canadian citizenship status?
So that's really interesting because Canadian law really links citizenship to genetic links. And that's kind of changed, and we'll talk about that a bit later. But generally, if there is a genetic link, it's the easiest possible way to demonstrate citizenship, and you essentially have citizenship by descent. This is an automatic grant of citizenship, so you do not have to apply for citizenship. So essentially, if a Canadian citizen has a child, then their child gets citizenship by descent, as long as they were born in Canada. The best way to demonstrate this, often, especially in the surrogacy realm, is through DNA testing. DNA testing is traditionally and often very done in surrogacy anyways, and we essentially use the DNA test to demonstrate the biological link.
And what happens if there's no genetic link between the intended parent, who is a Canadian citizen, and the surrogate child?
This is a really interesting question and has kind of really been debated in the courts in Canada. We finally have some resolution, and the way that Canada now looks at it is that there is citizenship by descent when there's a DNA link, but also parents who have been recognized as the child's legal parent at birth, either through an original birth certificate or by relevant birth records, so surrogacy contracts, court orders, hospital records, etc. They're also eligible to pass down citizenship without a gestational link or a biological link. So essentially what had happened is this had gone to court, the government fought it, the Quebec courts did find that this was discriminatory in some ways, and essentially instead of taking it up, the Canadian government put in a public policy that is now being honored, and essentially now if they can prove that they were recognized as the child's legal parents at birth, especially in jurisdictions that allow for that, then citizenship is passed down. However, it is important to remember that there is that caveat of at birth. So if they adopt the child a year later or in a long-term process afterwards, then there's an application for citizenship that has to happen. It's not citizenship by descent.
So for Canadian intended parents who are citizens, but perhaps were not born in Canada, is there a one-generation limit to granting Canadian citizenship to their offspring?
Yeah, so there is a one generational limit. This is kind of came about in the Citizenship Act changes that had come out in 2015. Essentially, the best way that I explain it to people is if you were born in Canada and you have a child overseas, that child will get citizenship. As we spoke about before, they get the automatic grant of citizenship by descent. However, if that child then has a child overseas, I guess the first person's grandchild or that individual's child will not get citizenship by descent. So it only goes down one generation. And this is very important to note, especially in overseas surrogacy. I always inform parents that even though you're passing down citizenship by descent, that doesn't go down again and again in perpetuity. It only has a one generational limit.
Aadil, when do you recommend that intended parents first contact your office to get this process started?
So our recommendation is that once there is confirmation that the surrogate is pregnant and that they know that they want to be coming back to Canada, that we start the process. We cannot submit any documents or give anything to the government until the baby is actually born. However, when intended parents have the child in hands, they're pretty anxious to get back to Canada as fast as possible. And so what we do is we would provide a document list to individuals well before the birth date, because intended parents are usually very busy with a new child after that and don't want to be dealing with the paperwork. We get all the paperwork ready and cleared and at least give a list of people, documents that they require for after the birth to make sure that we have everything on hand. And this way we're able to put in an application as fast as possible after the birth. But one of the required documents that we will need in order to submit is definitely the birth certificate. And if there is an adoption taking place, then we would need confirmation of that adoption prior to submitting all these applications.
For Canadian intended parents who completed their surrogacy journey in the United States, they may have been given a pre-birth order or post-birth judgment documents. What exactly does your office need to complete the process?
We usually will provide a full document list, and it does change. When there are pre-birth orders, it does make it a little easier. Like I alluded to, especially when it is when there's no biological connection. In those instances, we can see that the parents have been recognized as the child's legal parent at birth or even before birth. So that does make that issue a lot easier and stringent. And it just gives us our documents a little earlier. So if there is a pre-birth order, it is useful to us. However, we still cannot submit up until actually the birth has happened, but it doesn't provide, it does allow us to submit those applications faster because that issue is already resolved.
When do Canadian intended parents need to return to Canada to complete this process, and how long do they have to stay?
So that's really interesting and has become very interesting during COVID because people don't want to be traveling as fast as possible, and they're often staying in the country that they're in because they don't want to put their baby at risk in terms of travel right now. It really depends on the status of the parent and the baby. So if it's a citizenship grant, for example, if it's a grant by birth, if they're Canadian citizens by biological connection or have parents recognized as legal parents at birth, they can start applying for the citizenship certificate from anywhere, and you can start it right away. They do not have to be in Canada. If they are permanent residents and they are doing a sponsorship application, then they do have to be in Canada. A citizen can sponsor from overseas, but a permanent resident cannot. So a permanent resident has to be living in Canada when the sponsorship process goes into place. So they would have to return to Canada and put in the sponsorship application at that time.
Aadil, we talked about a lot of statuses today, whether it's a Canadian citizen or Canadian permanent resident, whether there's a genetic link or no genetic link. How can intended parents get a more accurate idea of the costs associated with this process?
Because we've spoken about so many, we're kind of all over the maps. And what I have found is that although these processes seem to be very siloed, it's very different depending on almost every family and what their goals are, what their biological connections are, what their birth story is, when they want to be coming to Canada. So the way that we have set it up is that we do provide consultations for intended parents prior, even often when they're actually considering surrogacy. so that they understand what's happening. And from the consultation, we come up with an immigration plan, and it's there that we would provide a fee structure for exactly how much everything would cost. And so parents are never surprised going into the process. All of our fees are done as fixed rates. So we don't do hourly rates, we do fixed rates on our fees, and we inform people of it well in advance.
This has been a conversation with Aadil Mangalji, a partner at Long Mangalji in Toronto, Canada. Thank you so much for your time today. Really appreciate talking to you.
Thank you. It was great. And I'm really happy to speak to you guys about all of these issues and these topics, because I find them fascinating myself, and would be happy to speak to anybody about this further, about their own individual cases in a consultation.
GSHC